Last week, I uploaded a video on how I would sue a police officer and the municipality for the violation of my Fourth Amendment right under 42 U.S.C. 1983. And your responses were so overwhelming in a good way that I decided to produce a 12-part series of how to file a 42 U.S.C. 1983 claim from start to trial. Now, of course, the information that I will present will not be exhaustive of the information that's available to you. However, it will get you started and it will give you a fighting chance to get justice. And in today's video, part 2, we're going to talk about serving the police officer and the municipality and avoiding a dismissal for failure to properly serve. So let's get started. And we're going to look at Federal Rules of Civil Procedure 4M, the timeline. First, a summons must be served with a copy of the complaint. Next, the complaint must be served upon the defendant or defendants within 90 days of filing the complaint or the pleading. 3, the plaintiff is responsible for having the summons and complaint served. 4, the plaintiff must furnish the necessary copies to the person who makes service. Now you want to check with your jurisdiction to determine how many copies are needed. And 5, any person who is at least 18 years old and not a party to the lawsuit may serve a summons and complaint. Again, a party cannot serve the lawsuit. 6, plaintiff may request that service be made by a marshal or person who is specially appointed to serve. And 7, if the pro se is authorized to proceed in forma pauperis, the court must order service by marshal or person specially appointed. But again, you want to review the jurisdictional rules. So let's look at serving individual capacity claims versus official capacity municipality claims. Suing a police officer or government official in their individual or personal capacity means seeking monetary damages directly from the officer's personal assets and bank accounts for constitutional or legal wrongs committed under color of law. Suing a police officer or government official in their official capacity means seeking monetary damages from the municipality police department for constitutional or legal wrongs committed under color of law. Now, in terms of naming the defendant officer in his or her official capacity, the courts would not prefer that. Courts generally do not prefer an official capacity designation to an officer when the municipality is also a named defendant in the caption. And the reason why naming the defendant in his or her official capacity is the same as naming the municipality. And I encourage you to look to the local rules and learn the posts of the judges in the district the case will be filed in. By the way, I always like to learn something about the judge who's going to be presiding over my case or over my client's case. So let's talk about how to serve individual capacity claims. 1, personal service. You can hand the documents directly to the police officer. The process server now, not the pro se. Remember, pro se plaintiff cannot serve because they are parties to the lawsuit. But the documents can be handed directly to the police officer. This can be done anywhere, including when they are arriving at work, leaving the station, or out in public. Residential service. The officer can be served by leaving a copy at the officer's personal home with someone of suitable age and discretion who also lives there. Authorized agent. The officer can receive the documents delivered to an agent explicitly authorized by the officer or by law to receive service. State law rules. Follow the service rules of the state where the federal court sits or where service happens. Some states allow service by certified mail. Let's look at serving official capacity municipality claims. Personal service. When a party sues a municipality and its police department, the mayor, city clerk, or city attorney is typically served on behalf of the city, depending on local rules. Check local laws. State civil procedure rules list the exact people who can accept legal papers for local governments. And it's all right to call the governmental entity to find out who accepts process service. Serve the right office. You must deliver the summons and complaint to the official office during normal work hours. Separate police notice. You may also need to serve the police chief or a specific city risk management office depending on state law. Let's talk about waiver of process of service. Requesting a waiver. An individual, corporation, or association that is subject to service under Federal Rules of Civil Procedure, Rule 4E, F, or H, and you can review that under the rule, has a duty to avoid unnecessary expenses of serving the summons. The plaintiff may notify such a defendant that an action has been commenced and request that the defendant waive service of a summons. So we have four things we want to focus in here. The complaint, Form A0398, Form A0399, and certified mail. So we know about the complaint. We know that the complaint has to be part of the process service. And this form is A0398. The plaintiff will send this form to the defendant, putting them on notice that a lawsuit has been filed against them and requesting that the defendant waive formal service of a summons. Follow the prompts. And it's pretty self-explanatory, right? Okay. And in this form, A0399, this is what the plaintiff pro se sends to the defendant: the waiver of the service of summons. And assuming that the defendant will agree to waive service, they will return this document to the plaintiff. And notice in the first sentence it says, I have received your request to waive service of summons in this action, along with a copy of the complaint, 2 copies of this waiver form, and a prepaid means of returning 1 signed copy of the form to you. In other words, you're sending the defendant 2 copies of this form in a self-addressed envelope where the defendant can return this to the plaintiff. Okay? And lastly, make sure that it's sent certified mail. Return receipt. So next week, we're going to talk about qualified immunity and the defendant's initial responses. So follow along with us. And until next time, I'm Advocate Lucinda B. M.